we are going to read our second lecture in which we will cover doctrines and evolution of our constitution. Okay, let's start it. So finally we are here and we will read today key doctrines in Indian polity. First is separation of power. What is separation of power? Is an approach to a govern a state. इसके अंदर जो state government है is divided into two branches, each with separate independent power and responsibilities, that the power of one branch are not in conflict with those of the other branches. And theoretically we may say and doctrine of separation of power is there in India, but it is only between the executive and judiciary. The prime minister is a part of union executive, yet it is the prime minister and the council of ministers who are the real executive, because of the president has to act and aid the advice of the council of ministers. Thus, council of ministers work in the capacity of both legislative and executive capacities, which goes against the doctrine of separation of power. And the second one is constitutional provision. Article 50 कहता है judiciary and executive should be separate. Article 121 and 122, judicial conduct of Supreme Court and High Court judges cannot be discussed in Parliament and state legislature. याद रखो आर्टिकल 121 and 122. Article 361, what it says? President and governors are not answerable to any court for the exercise and performance of their official duties. And we have come to the next, that is judicial pronouncement. In this we will read case of Nanda Bharti case. Separation of power is an integral part of the basic structure of the constitution. Indira Gandhi versus Raj Narayan case 1975, in which Supreme Court observed that separation of power was limited in India. The Supreme Court rejected the NJAC Act 2014 as it threatened the independence of the judiciary. Okay, we have read the key doctrine of Indian policy. Those were separation of power and constitutional provisions, judicial pronouncement. Now we will come next on doctrine of checks and balances, one of the most important doctrine. Checks and balances is the principle of government under which separate branches are empowered to prevent the action by other branches and are induced to share power. Checks and balances are applied primarily in the constitutional government. They are fundamental importance in tripartite government, such that there are the United States with separate powers among legislative, executive, judicial branches. In Indian context, check on the judiciary. The judges of the Supreme Court and the High Court are appointed by the executives, but they may be removed only if they are impeached by the parliament. Check on the executive is responsible to the legislature in its functioning. Check by the judiciary on the legislature and the executive through the tool of judicial review and using the doctrine of basic structure. In the judicial innovation that was pronounced in the Keshav Nanda Bharti case on 24th of April 1973. Through this, judiciary put a limitation on the amending power of parliament, so that the basic structure of the constitution can't be amended under Article 368. Court held that no part of the constitution was beyond the parliament's amending power, but the basic structure of the constitution can't be amended even with the constitutionally amended act. The power to amend is not a power to destroy the constitution. The court didn't define the basic structure, but only listed few principles as being its part. Several such principles have been propounded by the court from time to time. For example, S.R. Sommai, यहाँ पे secularism 1994, judicial independence and judicial review in L. Chandra Kumar case. Next, majority. It is functional instrument used in parliament to carry out several businesses like amendments to the constitution, appointment and removal of official and working of parliament. What is simple majority? It is only the 50% present and voting. And इसके यूज क्या क्या होते हैं? यहाँ पे passes of ordinary bill and financial bill. या फिर फाइनेंशियल बिल हो वो पास होता है. पासेज ऑफ एडजर्नमेंट, इलेक्शन ऑफ स्पीकर एंड डिप्टी स्पीकर, अप्रूवल ऑफ प्रेसिडेंट रूल and financial rule, censor motion, resolution passed by the House of Parliament for decontinuation of the national emergency, ratification of the constitution by state legislature. ये सब काम होते हैं हमारे सिंपल मेजोरिटी से. अब हम पढ़ेंगे absolute majority is not less than 50% of total strength of the house without subtracting vacancies, not used alone, it is used with other majorities, that is absolute majority. And now we will read what is effective majority. This means not less than 50% of the total strength of the house vacancies excluding vacancies. यहाँ पे हम this is needed in the removal of speaker, deputy speaker, vice chairman, etc. Let's come to special majority. This is not less than 2/3 member present and voting. No minimum requirement. इसके uses होते हैं आर्टिकल 249. यहाँ पे राज्यसभा कैन पास अ रेजोल्यूशन ऑथराइजिंग द पार्लियामेंट टू लेजिस्लेट ऑन द स्टेट सब्जेक्ट फॉर मोर देन 1 year. आर्टिकल 312 राज्यसभा कैन पास अ रेजोल्यूशन ऑथराइजिंग द पार्लियामेंट टू क्रिएट अ न्यू ऑल इंडिया सर्विस. सेकेंड, नॉट लेस देन 2/3 member present and voting with absolute majority. That comes under article 368. Example, removal of judges of Supreme Court, High Court, CAG and CEC. Approval of continuing nation emergency in both houses. Article 169. In a state assembly seeking to create abolish Vidhan Parishad. Next point, 2/3 of total strength of the house. Impeachment of the president. Next point, constitutional amendment require consent of 50% of the state needed on the matter of distribution of executive or legislative powers between center and state, on the matter involving Supreme Court and High Court, on the matter involving against list of 7th schedule, representation of states in parliament, and amendment in the procedure of election of the president. Article 368 itself that can be amended by special majority. And GST, Goods and Service Tax Council. Now next, political theories. Let's read political theories. These are, first one is liberty. What is liberty? It is the absence of constraint and facilitation to the ability of the people to choose, believe and act on their potential. It's an external construct. It's personal freedom that is granted to people by external authority. Example, liberty of thoughts and expression, belief, faith, expression and worship in Indian Constitution. Liberty are of two types. First one is negative liberty, second one is positive liberty. Negative is known as liberty from law. Its narrow interpretation, it focuses on absence of constraint. And the positive liberty is known as liberty by law. It has wider interpretation. It focuses on facilitation to environment, developing full potential on and of an individual. Next one is freedom. What is freedom? It is absence of constraint and facilitation to the ability of people to freely express themselves and develop their potential. It is internal construct where one individual decide his own action. It is the capability of an individual to make decision without external control. Next one is republic, absence of privileged classes. Let me repeat this again. Absence of privileged class and political sovereignty with people. Next one is equality, absence of special privilege to any section of society and provision of adequate opportunity for all individuals without any discrimination. Sovereign, freedom of country to conduct its own affairs both internally and externally. Democratic socialism, that is faith in public and private sector coexistence. Secular is independence of state action from religious influence. Indian secularism is a positive secularism where all religion enjoy equal status. Democratic, possession of supreme power by people. Parliament democracy, it is arrangement of government where executive is responsible to the legislature for its policies and actions. Feminists are those men and women who believes that many of the inequalities we see in society between men and women are neither natural nor necessary and can be altered so both women and men can lead free and equal lives. Social justice is a political and philosophical theory which assert that the dimensions to the concept of justice beyond those embodied in the principle of civil or criminal law, economic supply and demand, or traditional moral frameworks. Rights. These are the legal, social, or ethical principles of freedom or entitlement. That is, right are the fundamental normative rules about what is allowed of people or owned to people according to some legal system, social convention, and ethical theory. Now,